Hello everyone. I am Prachi Gupta, Assistant Professor at IIMT College of Law, Greater Noida. Today my topic is sedition law. So let's start. What is sedition law? So there are some uh, subheadings under this topic. We will discuss about historical background, definition of the sedition law, essentials of sedition, the Law Commission report on sedition law, and judicial pronouncement on sedition. At last, constitutionality of sedition law. Okay, so let's start. Sedition. What is sedition law? If we ask what is sedition law, we will see that sedition law in India is a legal provision that deals with the action or speech that are considered to be against the country's government. The law is intended to maintain public order and protect the integrity and sovereignty of the nation. The law is primarily aimed at preventing acts that can lead to violence or pose a threat to the security and harmony of the nation. Before starting the essentials of the sedition law, let's see what's the historical background of the sedition law. That sedition law was initially formulated in 1837 by Thomas Macaulay. British historian politician was explicitly suppressed when the Indian Penal Code was adopted in 1860. Section 124A was added in 1870 by an amendment instituted by Sir James Stephen. A separate section to deal with the pollution was felt necessary. It was one of the main stringent laws adopted to suppress any violence or voices of disagreement at that time. So this section is implemented in IPC. Okay. In 19th and 20th century, the sedition law in India was utilized mainly to suppress the writing talks of notable Indian nationalists and freedom fighters. The first known occasion of the application of the law was the trial newspaper editor Joginder Chand Bose in 1891. The first other significant example of the application of law comprises the trial of Bal Gangadhar Tilak, Mahatma Gandhi, Jawaharlal Nehru, Abdul Kalam Azad, and Damodar Savarkar. Now we will see what the definition of sedition in IPC. So, according to section 124A of IPC, whoever by words, either spoken, written, or by sign, or by visual representation or otherwise bring attempts or attempt to bring into hatred or contempt or attempt to excite disaffection. The term disaffection is important here. Towards the government shall be punishable with the life imprisonment. So it is very harsh. Uh, it the punishment is up to the life imprisonment. According to explanation 1 of the section, it defines the scope of disaffection, and in explanation 2nd and 3rd, that indicate what under the English law is not considered seditious intention. So in India, what constitute and sedition is highly debatable. As per the IPC, for the act to be called seditious, it should have the following components. So, number 1, any word which can either be written, spoken, signed, which included poster, visible representation. So, it is the medium in which words and other spoken things are included. Second one is, it must bring hatred, contempt, disaffection. Hatred, contempt, and disaffection against the government. Third point is, it must be result in imminent violence or public disorder. As per the interpretation of the court on Section 124A Indian Penal Code, the following acts has been considered seditious: raising of slogan against the government, for example, Khalistan Zindabad by group of peoples, raising any slogan by the individual casually once or twice was held not to be seditious. A speech made by the person must incite violence, public disorder for it to be considered as a seditious material. Subsequent cases have gone to be further interpreted it to include incitement of imminent violence. Any written work which incite violence and public disorder. Sedition also include disloyalty in action. So sedition has been described as disloyalty in action. The object of sedition is include discontent and insurrection and stir up opposition to the government and bring administration of justice into contempt. Sedition is a crime against the society as it involves all those practices that result in conduct disturbance in state or to lead a civil war which contempt the sovereign and promotes the public disorder. So, what are the defenses available to a person who is charged with the sedition? So, what is the defenses given in IPC? Number one, to get the exception from the criminal liability, following are the defenses. Number one, that he did not make the sign, representation, or any speak, written or verbal, or not have done any act in question. So there was some element. If we choose, if we see that that particular element is not covered under the definition, so there are defense available for that person. So another is, one is if he did not make any sign or representation. Second one is if he did not attempt in contempt or attempt disaffection. Third one is such disaffection should not be towards the government. That means he can his disaffection could be against any other person but not the government. So sedition law basically covers in IPC, but there are other provision where few provision of sedition law also mentioned there. So these are the law where it is mentioned. Number one is IPC, as we all know, IPC in section 124A. After that, CRPC, Code of Criminal Procedure, there is section 95. And then Seditious Meeting Act 1911, and at last the Unlawful Activity Prevention Act, and under which section 20 of clause 3. Okay, so there are there are report by the Law Commission which recommended few suggestion about the sedition law. The Law Commission report on sedition. What in this report? In previous report of 1968, the Law Commission had denied the notion of Sedition Act. After that, in 1971, the committee wanted the scope of the section to be broadened. It called for the covering the constitution, the legislature and judiciary within the scope of the law, in addition to just government, since the discontent against any of these institutions is unacceptable. The only delusion the commission desired was to alter the broad gap between two jail term stipulated either 3-year or life imprisonment. It called for fixing the highest sanction at least 7-year stringent imprisonment with a financial penalty. In recent August 2018, the Law Commission of India published a consultation paper implying that it is the time to rethink or repeal the section 124A 124A of the IPC that deals with the sedition. The Law Commission had recommended invoking the section 124A just to criminalize the act committed with the intent of disrupting the public order or the overthrowing the government by the way of violence and unlawful methods. Recently, there is also a change in 2024. There is also a judgment about it. We will discuss this at the last of the of this topic. So there are few cases which were pre-independence era. It was very famous. Sedition trial of Lokman Tilak in 1897. Bal Gangadhar Tilak published the reports of commentation followed by the 1894 paper by Professor R.P. Karakaria on the Maratha King Shivaji. Karakaria submit his paper to Bombay's Royal Asiatic Society in 1894. This paper led to the early commemoration of Shivaji coronation. After that, Tilak published the report of celebration. Tilak started these celebration as Shivaji utterance in his dailies Kesari and Maratha. Justice Arthur Strache presided over the case. This sedition trial is famous historically as in this case an effort to excite the feeling of hatred against the government was also placed under the scope of 124A, terming it to be seditious. Therefore, it extended the understanding of section 124A. Tilak was sentenced to the 18 month of stringent imprisonment. Okay. In this case, he ultimately was sentenced with 18 months of stringent punishment. So, what is the constitutionality of sedition? The concept of free speech has attained the global importance, and it is basic fundamental right of human being. In India, such rights are provided in the Part 3 and Article 13-19 of the Indian Constitution. The said right has no geographical indication because it is the right of citizen to gather information with the others and exchange the thought and views within or outside the India. Courts have been given the power to act as guarantor and protector of the rights of the citizen. Article 19(1) subclause A secure the freedom of speech and expression, but it has been bounded by the limitation which has been given under the Article 19 clause 2 of the Constitution, which states the permissible legislative abridgment of rights of free speech and expression. So there are few restrictions under Article 19 subclause 2. In Niharendu, the case for sedition, federal court had taken chance to interpret the section 124A of IPC in alignment with the British law. It had ruled that the tendency to disturb public order was an essential element under the 124A. The Privy Council held that the incitement to violence and tendency to disrupt a public order was not necessary under the Article 124A. By the First Amendment, there are few changes in the Constitution. That is, first, considerably widen the latitude of the restriction on the free speech by adding the further grounds. And second one is the restriction imposed on 19(1) subclause 2 must be reasonable. Therefore, the question now arises of whether section 120 of IPC is in conflict with the Article 119 of the 19 subclause 1 or under subclause A or not. It has been reflected by the following points. That's what the points are. They are mentioned here. Section 124A of IPC is ultra vires and ultra vires the Constitution in as much as it infringes the fundamental rights of freedom of speech as given in Article 19(1)(a) and is not saved by the expression in in interest of the public order. Second, as expression in interest of public order has been wider connotation and should not be confined to only as an aspect of the public order, then the section 124A is not void. Section 124A is partly void and partly valid. In Indramani Singh versus State of Manipur, it was held that Section 124A, which seeks to impose restriction on exciting disaffection, is ultra-virus, but restriction imposed on the freedom of speech and expression covered under the Article 19, Clause 2 can be held intra-virus. So in 1959, Allahabad High Court declared that 129A, 124A was ultra-vires to Article 19, 1 subclause A of the Constitution. In Kedarnath Singh case, it was held that the law is constitutional and covered written or spoken word that had implicit idea of subverting the government by a violent means. That means in this case it was held constitutional, and in last case it was unconstitutional, ultra virus of the constitution. With the intention of creating public disorder, citizen can be criticized the government as long as they are not inciting people to violence against the government. So in recent case, it is very famous case for sedition law, SG Wompat Kere versus Union of India case. What guidelines are given in this case has been elaborated here. The Supreme Court stated that 152-year-old sedition law under the IPC, Section 124A should be stopped until the government re-evaluate it. Both the center and state government were advised not to file any FIR or continue any inquiry under the provision during the re-examination. So it is very important here to mention that Supreme Court further advised that it advised center and state government to not file any FIR as well as not to continue any inquiry under this provision during the re-examination. If a new case is filed under 124A, the affected party can seek relief from the concerned court. All ongoing hearing, appeals, and trial related to the charges under the 124A should be halted. That means it should be stopped there. Ruling on this section may be proceed if court deem it harmless to the accused. Third one is the Union of India can issue directives to state government or union territory to prevent the misuse of this section. The rigors of this section 124A IPC are not in harmony with the present societal context. Therefore, the court ordered the Union of India to reconsider the provision. While dictating the order, then CGI of the India stated that those already booked under the article section 124A are in detention cell can approach the concerned court for relief. Also, all the pending trials appeal proceeding related to the section 124A shall be kept in abeyance. Adjudication of the other section may be continued if it appears to court that no prejudice shall be caused to the accused. So at present, sedition law is on hold actually. No court ordered to not file any to not entertain any FIR further or any inquiry. So status quo on जो जहाँ पे है वहीं तक रोक दिया गया है. So at the conclusion, we can say that sedition law is sedition is a serious offense in violence of Article 19. So there is a need to sedition law should be expressly contain word which satisfy the restriction of Article 19 Clause 2. The purpose of restriction speech under Section 124A is to protection of national security, and sedition law should be interpreted and applied according to the guidelines given by Supreme Court as given in present case in SG Wompat Kere case. Thank you.